Good morning, everyone. Thank you for joining us today for the WARN Act webinar with Kevin Johnson with Johnson Jackson. Before we get started this morning, I just want to go over a few housekeeping items. This webinar is being recorded and will be shared out on the FRLA YouTube page later this afternoon. I will also share that link with all the attendees registered today. Please feel free to type in any questions that you may have in the question box, and we will try to get to those at the end of the webinar if there is time. Kevin, if you'd like to take it away.
All right, sounds good. So thank you all for attending. Hopefully everybody can see our screen, and you may have to put up with me in the corner, but feel free to move me way out of sight so you don't have to look at me. But what we're going to do today is focus on the WARN Act, and this is important because this is something that we may have to deal with in the future as we move forward. Some of us are thinking about closing locations. Some of us are thinking, it might even be necessary to wind up operations, at least for a while. And so if you're in either of those positions where you're thinking about cutting staff or thinking about closing a location, you need to know about the WARN Act. And so we're going to talk about it today. I'm going to try to put it in the perspective of the restaurant and hospitality business. And that's going to take a little bit of doing, because if you remember way back when this came out, you know that it came out in February of 1989. In the late 80s, for those of you who are around, were a time when we had a lot of factory closures in the Midwest. A lot of people were losing jobs. And so the Congress wanted to do something about that. And they didn't like the idea of plants closing and then all of a sudden people were out of work with no warning. So what they did is they passed a law that says that if you're going to close a plant or if you're going to do a mass layoff, then you have to give people at least 60 days notice of what's coming so they can get prepared for it. And the way this law is written, it's very much structured around sort of that industrial model because it talks about plant closings. So we are going to talk about it, and we're going to try to put it in a restaurant context and see what that means, because it does apply pretty much across the board if you have the right number of employees to be a covered employer. So here's what that means. We're going to break it down into 4 steps. The first step we're going to look at is whether you as an employer are covered by the WARN Act. And if you are a covered employer, is the employment action that you're thinking about taking covered? Is it something that would trigger the WARN Act requirements? If it would, is there an available exception that will get you out of otherwise having to give that WARN notice? And finally, if there is no exception that applies, then who do you have to provide notice to? Who does it go to? When do you have to give it? And what does it have to say? So the main thing that I want you to remember at the outset is that whether you need to worry about WARN is going to depend very much upon how many employees you have in the scope of the employment action that you are considering. So let's talk a little bit further about that. We're going to use some examples as we go through this. So you can pick the example that seems closest to you, and hopefully that'll help us think about it and understand how it might apply to us. Our first example is going to be Ike's Independent Pub. This is an independent bar. It's got 20 employees. Then we have Fanny's Falafel, and this is a franchisee that's got 10 locations, and it takes about 25 employees to run each location. Then we have Matt's Microbrews, and this is a regional gastropub. It's got about 15 locations, and it takes 45 to 60 employees per location. And finally, we're going to have Hayden's Honeymoon Beach Resort, which is a beach hotel, which has about 300 employees. And you'll see how the size and the scope of the actions matter when you apply them to those different types of employees. So the first step we have to figure out is, are we a covered employer? And to do that, we go look at the statute. And what's interesting about the statute is it has 2 different methods for counting whether you're covered. The magic number is 100 employees. If you have 100 or more employees in your operation, then you're covered. But there's 2 different ways to count it. One is to count all of your regular employees, but not your part-timers. And that's what we call the 1A version of this. The other way to do it is to say that you have 100 or more employees of any type if they work more than 4,000 hours a week in the aggregate, exclusive of overtime. And what that does is basically say, if there was an employer that was trying to avoid this by just hiring a bunch of part-time people, but their part-timers add up to the equivalent of 100 or more full-time employees, then they're going to be covered. So you can see how they've sort of tried to build in a defense to people who might otherwise game the system. So when do we measure whether we have 100 or more employees? Because obviously that can fluctuate. We have to measure on the date the notice would be due, okay? So that requires a little bit of anticipation on our part, and it requires us to get a little bit down the road and say, okay, we think we're covered. Now let's figure out, if we have to give notice. And if we have to give notice, let's count back 60 days from that notice date and make sure we were right about whether we had 100 employees on that date. So I'll give you a couple examples and we'll work through them. Let's start with the 4 that we talked about initially. Okay, well, before we get there, let me give you a couple ground rules for it. Okay, we've already said we're going to count on the date the notice is anticipated to be due. Okay, and that's 60 days before the employment action takes place. The second ground rule is that you have to count all of the different sites of employment. So that franchisee that has 10 locations, they've got to count the employees at every location. Same thing with microbrews, okay? Matt's Microbrews has to count all 25 or however many locations they had and add up all those employees. Well, what if I've got employees who are on temporary layoff or leave? Maybe they're out because of, some sort of COVID-related leave. Maybe they're on FMLA. I have to count them. They're still on my payroll. They're part of my head count. What if I've got subsidiaries or contractors that are on site? This might be interesting for somebody like the hotel that might have some contractors that are filling some key roles. Let's say there's a contractor that's running the cafeteria and has a bunch of employees on site running that. They would have to probably count those employees too if they're considered to be a joint employer of those employees, which usually comes down to whether they have control over them. You're going to count even those who aren't entitled to notice, okay? Because that's something we're going to get to later, is if you have to give notice, who do you have to give it to? And what's really weird about the WARN Act is sometimes employees that are counted for the first part don't actually end up being people that you have to give notice to. But for the first part, these are the rules we're going to follow, okay? Now, what is a part-time employee? Because that's really critical. We said we weren't going to count the part-time employees under 1A. A part-time employee for WARN Act purposes is an employee who's employed for less than 20 hours a week when we look at the most recent 90 days. So that makes sense, sort of halfway. That's your guideline for what's a part-time employee. But then here's where it gets weird. It also refers to someone who is essentially a new or a short-time employee. So if they've been employed for fewer than 6 of the 12 months preceding the anticipated notice date, then that's considered a part-time employee, no matter how many hours they're working. So you might have somebody that you just hired. You might have a bunch of them. I mean, the hospitality industry does have a relatively high turnover rate. So if you have a bunch of new employees, you might not have to count those when we start doing this test, at least under 1A. So we'll talk through that. I'll give you a couple of examples so you can see how it might work, because this is something where it always makes more sense to get in and look at examples rather than try to guess it from the statute. All right, so let's go back to our examples. Remember our independent pub? It only has 20 employees. It is not covered by the WARN Act. So if that's you, if you're a single location employer and you have less than 100 employees, you are not going to have to worry about the WARN Act because you're not big enough to be covered by it. The rest of our examples, they're all covered employers under the WARN Act. Our franchisee here, they had 250 employees, okay? Matt's Microbrews had approximately 800 employees, and Hayden's Honeymoon Beach Resort had around 300 employees. So they will all be covered employers, and they're going to have to look at step 2 to figure out if they have a covered employment action, okay? So this sounds really straightforward, and in practice it is. It's fairly easy to count employees unless you are close to 100 employees, all right? When you are close to 100 employees, you really need to go check with a good labor lawyer, because such things as the number of the hours worked or the number of months worked by each employee can really make a difference. I'm going to give you an example so you can see how it might come out differently under those 2 definitions. Here's the first one. This is Johnson's Cafeteria, okay? It's going to have some problems in COVID because nobody wants to eat at the cafeteria now. And so even though it's the home of the meatless meatloaf, I don't know if that's going to be enough to keep it in business. So let's assume that my cafeteria has 90 full-time employees who work at least 50 hours a week. All right, so we got a bunch of hours and we got a bunch of full-time employees. But 10 of those 90 have been there less than 6 months. So they might be part-time under our definition of part-time employees. We also hired 10 temporary employees who are going to work 30 hours a week during snowbird season. And we have 30 long-standing part-time employees who average 15 hours a week. So are we covered? Here's how it works under that first definition. Okay, those 90 full-time employees are our starting point because they're definitely full-time. But 10 of those have been there less than 6 months, so they're part-timers, and I get to subtract them. Now I'm down to 80. That cafeteria hired 10 temporary employees to work 30 hours a week. Now, although they're working more than 20 hours, they've been there not enough months to qualify. And so they are part-time by definition. We're not going to count them, so we're still at 80. And we have 30 long-standing part-time employees who average 15 hours a week. Now, those employees, are working less than 20 hours a week. So they are part-time and they don't count. So under A, I end up at 80 employees, and I'm not covered under the first part of that definition. But now look what happens when I do it under the second part of the definition. Those 90 full-time employees, when I count their 40-hour regular work week, I get 3,600 hours, okay? I still have to count my part-timers under this second definition. So now I've got, those 10 still included. I can't subtract them, so I'm still at 3,600 hours. My 10 temporary employees, I have to count their hours. So they're working 30 hours a week. Now I'm up to 3,900. And those longstanding part-time employees who average 15 hours a week, I got to count them too. So now I'm up to another 450 hours. That gets me over 4,000 hours, and I'm a covered employer under the second part of that definition. So you see why it's tricky. If you're anywhere around 100, you really have to go back and have someone work through these definitions with you and look at your payroll really closely for how many hours they worked and how long they've been there. Most of you won't have to worry about that, but if you are close, I do want you to understand how important that is. So what about employer coverage? The first thing you need to know here is that there's generally no individual liability for supervisors. So if you're the manager of the restaurant and your owner gets it wrong and fails to give WARN Act coverage, you're not going to be individually liable. The owner, the employer will be. Now, you may have situations where you have closely held companies. Let's say you've got 2 restaurants that work, very closely together. They're owned by the same owner. They have a lot of interchange of employees, and sometimes people work a couple days a week at one restaurant, and then they go, to the other side of the intercoastal, and they work, the weekend at the other place. All right, but a lot of interchange, common ownership, common control, and unity of personnel policies. That will probably be treated as a single employer rather than 2 separate locations, okay, for purposes of counting for 100 employees. So you need to be careful if you fall into that, not just assume that because you have nominally separate companies that you're going to automatically be outside the 100 employee rule. All right, so our second step is we're going to look and figure out, do we have a covered employment action? And again, we're looking for 2 things. We're looking for a plant closing or a mass layoff. So when I say plant closing, instead of thinking about a factory, just think about a shutdown of any facility. So if you're shutting down your restaurant or shutting down your hotel, that could be a plant closing. And a mass layoff is more like a reduction in force. That's when you're laying off a bunch of employees. The definitions of both of those terms, the definitions for plant closings and mass layoffs, depend upon these terms right here. They depend on the single site of employment test and the definition of employment loss. And so you're going to have to know those before you can decide whether you have a plant closing or a mass layoff. So what does that mean? A single site of employment is a single location or a group of contiguous locations. They have reasonable geographic proximity, they're used for the same purpose, and they share personnel, okay? So let's give a couple of examples here to help work our way through that. So here we have, a fabrication yard that, was relocated after Hurricane Ike, but the staff regularly carried out business at the yard, and the employees from the yard often came to that remote building where the headquarters was and interacted with the administrative staff. So just because, the headquarters got moved off site didn't necessarily mean that it was a separate single site of employment. Both of those locations together had to be considered a single site. And so that would be, indicative of maybe the headquarters for the restaurant is, a block away, but, the management is in there and out of it all the time and is always down at the restaurant. You can think of that as a single site of employment. But here's an example where these were all considered to be separate sites. These were coal mines. Each coal mine had separate facilities, independent production, independent management, no sharing of employees, and different union representation. So maybe you have something where it's more analogous to two different concepts that, maybe at the very top levels have some common ownership, but, they're totally different concepts. They have different management structures. They do not share employees. They have maybe different, benefits plans, things like that. They're not going to be considered a single site of employment, even if maybe they share a parking lot, and even if they're taking advantage of that common location and are sited, very close to each other, because they are so independent in how they're set up and run. Again, this is very fact specific. So if it's close and you have some factors cutting both ways, you're going to want to talk with your employment lawyer and make sure you understand. So now that I know what a single site is, I have to measure whether I have employment losses taking place at that site of employment. All right. So what's an employment loss? Well, obviously a termination is. But let's say right before my planned termination, somebody retires. Do I have to count them? No, I don't. What about a voluntary quit? Somebody just walks out, throws his apron down and says he's done and, screw all of us. Well, that's not a termination by us. That's a voluntary quit by him. And so I don't have to count him as being part of the termination of employees because he was gone before it happened. A discharge for cause. So if I'm firing somebody for sex harassment the day before I do, my RIF or my plant closing, they don't count against my total. Now, what if I put them on layoff? If I say, listen, I'm going to do a furlough here. I'm trying not to close this location, but I just think we're going to have trouble making it through the slow months. So we're just going to shut down during the slow season. We're going to try to reopen it back up when we get to the busy season. But that means we're probably going to be out of work for about 6 months, maybe 7, until we can get into, the height of tourist season. Well, guess what? You now have a layoff that exceeds 6 months. That might actually require you to give notice under WARN because that could be a covered employment loss. And finally, if you have a reduction in hours of work of more than 50%. So that would be a situation where maybe you're looking at it staying at the hotel, that my choices are either I can lay off, 120 people, or I can just cut everybody's schedules in half and we'll spread the pain out. So everybody will take a cut and we'll all feel it equally. Well, now I've reduced hours of work by more than 50% for a larger number of people. That might put me over the threshold because I have to count that as an employment loss. All right, so now that we understand the terms, what is it that we're looking for at the second step? We're looking again for either a plant closing or a mass layoff. So let's do the definition for plant closing first. A plant closing is a permanent or temporary shutdown of a single site of employment or one or more facilities or operating units within a single site of employment if the result is an employment loss for 50 or more employees during a 30-day period, excluding part-time employees. So what's this 30-day period here referred to? That's the period of time that I'm going to use to count whether I have employment loss for 50 or more employees. That doesn't refer to the duration of their employment loss. It just means that's the window in which I'm looking to see if the employment loss adds up to 50. Let's go back up to the top. When I'm talking about permanent or temporary shutdown, permanent shutdown is easy. I'm closing that restaurant, it's never coming back. But what about a temporary shutdown? What if it's, we've decided we are going to shut that location down. We're going to raise the building. We're going to put up a new prototype store, on that out parcel, and then we'll hopefully bring everybody back a year from now. Well, that might be a temporary shutdown. That might be enough to put you into a plant closing. You're looking again at a single site of employment. So I have to do, it has to be a shutdown of that single site of employment. But what if I'm not shutting down every piece of the business at that single site of employment? All right. Let's say maybe I've got, I've got a hotel and it's got an associated restaurant with it, or some sort of, amusement park or something that's on site, on property, that is really integrated into it. And I'm going to keep the hotel, but I'm shutting down the restaurant. I'm shutting down the amusement park or whatever the attached facility is. That could be considered a separate facility or operating unit at that single site of employment. And even though I'm not doing a full shutdown of all of the business at that single site, I might still qualify. Now, what am I looking for? I'm looking for an employment loss for 50 or more employees. And again, we are excluding the part-time employees. So I've got to go back to that definition. And when I do my counting, once again, I'm excluding those that work less than 20 hours or have been there less than 6 months. Well, what if it's not a plant closing? What if all I'm going to do is lay off a bunch of people? Then I might have a mass layoff. A mass layoff, by definition, is a reduction in force that is not the result of a plant closing, and it has to produce two things. It has to produce an employment loss at a single site of employment for more than 33% of the active employees, as long as that exceeds 50, okay? Or if I lay off so many people that it's more than 500 employees, then that's a mass layoff regardless of whether it's a third of my workforce. And you can see how that might apply if you're shutting down like a General Motors plant, okay, or doing a mass layoff there. I might lay off like a whole production line, and it might result in 1,000 people losing their jobs. So even if there's still 5,000 people working at the plant so that I'm not getting to the 1/3 mark, that would still count. But in the restaurant world, we're not going to have to talk about that too often, okay? So let's focus on this. Remember, my rule of thumb is it's a two-part test. I have to have more than 1/3 of the employees losing their jobs or having an employment loss of some sort, and that 1/3 has to be more than 50 in number. So if I go back, notice that under the plant closing, I had to have 50 or more employees affected, and under the mass layoff, the minimum number of employees affected has to be at least 50. So that tells me if whatever I'm doing is not going to affect 50 or more people, I don't have to worry about it under the WARN Act. So let's look at our examples. Fanny's Falafel wants to close 6 locations, right? Each location employs approximately 15 employees. My total employment loss is going to be 60 employees, but that employment loss is going to be spread over 6 single sites, and none of them will exceed 50 employees. So that's not a covered plant closing, and it's not a covered mass layoff. So if you're on this call and you happen to be a franchisee and you have a bunch of locations where you don't have more than 50 employees and they're all single sites of employment, you can breathe easier because you are most likely not ever going to have to worry about the WARN Act, because you're never going to have 50 or more employment losses at a single site of employment. Well, what about Matt's Microbrews? Okay, they want to close 6 restaurants. Their restaurants are more labor intensive. Each of them have between 45 to 60 employees. So their total employment loss for full-time employees is going to be about 300 people. But that's not necessarily the answer. What I have to look at is what's the employment loss at each single site, okay? Does it exceed 50 employees? I'm going to have to review each location. Remember, it's between 45 and 60 employees at each. So if I count them up and I find out that it's less than 50 full-time employees affected, then it's not a covered plant closing. And if they're shutting down the site and more than 50 full-time employees are affected at a location, then that business may have a covered plant closing at that site. So it's really, really important for Matt's to look at the number of employees and to go through that exercise of how many of those people are short time, have been here less than 6 of the last 12 months? How many of them are part-time employees or working less than 20 hours? Because that's going to determine whether I get over 50 at that site. Now, what about my hotel? Hayden's Honeymoon Beach Resort. It wants to close its doors, and it's a single site. It's got 300 employees. Okay, so we have a total employment loss for full-time employees. Let's assume it's about 250 once we get rid of our part-timers. That's going to be a permanent shutdown at a single site of employment, and it's going to exceed 50 employees. It's clearly a covered plant closing, so they're going to have to give WARN notice. Now, let's go the other direction with it. Let's say they just want to reduce their head count, okay? They want to bring their workforce down by about 40%. They have 300 employees. Let's assume they decide to cut all full-time employees, all right? And they're going to lose about 120 of them in this RIF. This is going to be a covered mass layoff because you're losing more than 33% of the employees at the site, okay? Because it's more than 100 out of their 300, and the total exceeds 50 employees. So they now have a mass layoff, and they're going to have to give WARN notice. All right, so remember how we talked about that measurement period? It's a rolling 30-day window. So if the number of employment losses exceeds that threshold during any 30-day span, you might have a plant closing or a mass layoff. So if you go back to that hotel, it might be thinking, geez, I know how I'll do this. Instead of laying off 120 people all at once, I'm going to space it out, all right? I'll lay off 40 people one month, 40 people the next month, and 40 people the third month. That way I never get above 50. It's never 50 or more in any 30-day window. So therefore I should be okay, right? Not necessarily, because the statute also has this way of checking to see if you're gaming the system. And it provides for a rolling 90-day window to be applied when you can't show that those layoffs are the result of separate and distinct causes. So in the example of that hotel, because that RIF was caused by one economic reason, one desire to reduce headcount, and all of them were part of a common plan, they're likely going to be aggregated within that rolling 90-day window, okay? And remember when we talked about when we're going to count? We're counting on the day that the notice is due. And so you're basically looking, at your 30-day window. And the way I tell people to look at this is, imagine that you have a calendar in front of you that's linear. It just spreads out, where each day follows the next on a scale from left to right. Now take your ruler that is 30 days long, slide it along that scale, slide it along that calendar, and see if you have more than 50 employment losses during any 30-day period. That's what you're talking about with a rolling 30-day window. So what does that mean? Okay, is there any way we can fix this? Are there any times where I could say, well, it looks like I'm covered, but maybe I can turn one of those employment losses into not an employment loss because it's close and I'm right at that threshold? Well, what about transfers? If I take that employee who would otherwise suffer an employment loss and I reassign them, or I transfer them to some kind of employer-sponsored job search or retraining where they're staying on my payroll, then they don't count as an employment loss. What if I'm closing, part of my business? I'm closing a couple of locations, all right? And I tell them that I will transfer you. So if I'm Matt's Microbrews, I'm closing down, my location in Brandon, but I say, well, I will transfer you to my Carrollwood location, okay? And you've got a job waiting for you. That might be a way to avoid it being an employment loss, because I've now offered to transfer them to a different site. It's going to be immediate in my case, so there's no more than a 6-month break in employment. Now here's the kicker. Is that within a reasonable commuting distance? Is it reasonable to commute to Carrollwood if you were commuting to Brandon? So we may have some dispute about whether that's close enough to be reasonable commuting distance. And you can apply that to your geography and think about what reasonable commuting distance might be. But let's say, even if it's not, let's say I said, I'll transfer you from my Brandon store or my Tampa store all the way down to Sarasota. Probably not a reasonable commuting distance, But what if the employee says, you know what, I've always wanted to live in Sarasota, and they accept that transfer? Guess what? It's not an employment loss because it was voluntary on their part and they took the offer. So those are ways in which we can use transfers to reduce employment losses below the threshold. Now, what about temporary projects? WARN does not apply to the closing of a temporary facility. Okay, so let's say the Super Bowl's coming to town and I've set up, my temporary facility out there and I'm selling the snow cones. And I hire a bunch of people to work for 2 weeks and then I lay them all off. They're not going to be covered. Okay, it doesn't apply to the closing of a temporary facility. And likewise, it doesn't apply if we have a strike or if we have a lockout and we have to replace the employees because they've gone on strike. Okay, let's assume we've got a covered employment action, and now we need to do a review to figure out if we can get out of having to provide notice. There are 3 main types of exclusions we have available to us. One is the faltering company exclusion. Another one is the unforeseeable business circumstances exclusion. And the final one is the natural disaster exclusion. And if I do any of those, I'm still going to have to give as much notice as is practicable, but it may excuse me from having to give 60 days worth of notice. So let's look at it. Faltering company exclusion is one that you use when you're trying to get capital or business to stay afloat. Okay, and so it's close, you're running out of cash, but you've got a potential deal with an investor or somebody who's going to come in and acquire you and pump a bunch of cash in that will let you continue operations. All right, if you're seeking that capital and there's a realistic opportunity to get it, and the financing or the business would have been sufficient if you got it to avoid or postpone that shutdown, then you may be able to use this. But you're going to have to show that if it was, if you'd given notice, that would have been made it impracticable. Okay, that the potential investor or customer or financing source would have been unwilling to provide that business or capital if you gave WARN notice, presumably because they would be worried that all your employees would vanish on you and you would no longer have a going concern. Okay, but if you can show that, you might be able to come up with faltering company exclusion. That's sort of a hard one to hit. So usually a more common one to focus on is the unforeseeable business circumstances exclusion. This applies to plant closings and or mass layoffs. The first one, was only for plant closings. This one applies to both. And this is when you have a layoff or shutdown that's caused by business circumstances that weren't reasonably foreseeable at the time the notice would have been required. So that implies that you have to have some kind of sudden, dramatic, or unexpected action that's outside your control. Well, how about government-ordered shutdowns? That would be a classic example of an unforeseeable business circumstance. So when a government shutdown catches you by surprise and you end up having to lay off everyone or shut it down because of that, then that's not reasonably foreseeable, okay, in most circumstances. And you can say, well, I'll give notice now that I'm aware that I'm shut down. And even if that's, notice that essentially you're out of work tomorrow, that may be the only notice that's reasonably practicable under the circumstances. It also covers unanticipated and dramatic economic downturns. So sort of like the issues we've had with COVID. The problem is the more this goes on and the more these things become reasonably foreseeable, then the more burden is on you to go ahead and give notice. So if we're looking at it and now it's becoming pretty clear that the economy is in the tank and we're going to the fall and business is falling off drastically, you're going to have a harder time just shutting it down and laying everybody off the next day, because somebody might say, well, you could see that coming. That's reasonably foreseeable. So really the focus is on whether that employer exercised commercially reasonable business judgment. And it's not a really tough standard, because the question is generally just whether that need for layoffs is probable, not merely possible. So just if I think, geez, this doesn't look good, I'm not liking the way the headlines are going, there's a possibility I might have to shut it down sometime in the future. That's not enough to require you to give notice. But when you're looking at it, you're saying, I really don't have any other choices, okay? This is a highly probable situation. Now you're in a position where you need to give WARN notice. Here's a couple of examples from the past. You may remember Arthur Andersen had suffered a criminal indictment because of the Enron scandal, and the whole firm just sort of evaporated. I mean, thousands of employees, within a month were just gone. And that was held to be an unforeseeable business circumstance because it was very sudden and dramatic and unexpected. And there's another one where an Alabama governor issued an executive order and he declared that the bingo games that were running at the Greyhound Park were illegal. And unfortunately here, the casino failed to give reasonably practicable notice. And so it did not have the exclusion available to it. But had it given practicable notice, it probably would have been able to take advantage of that exclusion. What about natural disasters, right? Because that's our third one. And it applies, first of all, to both plant closings and mass layoffs. And generally speaking, what you're looking at is a flood, an earthquake, a drought, a storm, some sort of big tidal wave, or similar effects of nature. So there's a real open question here as to whether the COVID pandemic is going to be considered a similar effect of nature. You know already, if you've been through some of these battles with people over business interruption insurance, that the insurance companies have taken a real hard line on that. And it's not a direct parallel to this, but there's some similarity here that the courts might say this isn't really the same as an earthquake. This is a human condition. It's something that is sort of spreading and creeping, and you can see it coming. And your layoff or your shutdown is not necessarily the direct result of the natural disaster. It's the indirect result because it's people staying home and not wanting to go out, or the government ordering them to stay home. So there's some questions here. There certainly have been a lot of cases filed, and there are some employers that have tried to raise this defense over the last few months. Just none of that litigation has gotten far enough to where we have any clear answers about this yet. But if that link is only indirect, you're better off relying on that unforeseeable business circumstances exception instead. Okay, what about selling the business? Maybe you're tired of it and you've decided, this is enough. I was ready to get out anyways. Let me sell. I've got this investor that wants to come in and buy it from me. They'll buy the franchise, or they'll buy, my independent company that I've built up, and it's time. Do I have to give notice when that sale happens and when we close and it all passes to them? Generally, no. Okay, that the transfer of the employees from one payroll to another is not employment loss. So if the restaurant keeps running or the hotel keeps operating, it just changes flag, then no, that's not enough to trigger WARN just because it got sold. But let's say that the new owner says, listen, we're buying it, but really what we're buying is we want the property and we want the building, but we're going to shut it down and we are going to not take the employees. We just want the hard assets. And then we're going to turn it into something else and do a major renovation. 6 months later, maybe we'll reopen. Okay, who's going to lay off all the employees? That's something you need to take care of and you need to account for in your sale documents, because the expectation is that you're going to lay them off before the sale closes. Then guess what? You as the seller have that responsibility. But let's say that the buyer doesn't think about that and they end up taking responsibility and they take on what amounts to a going concern, and then they suddenly announce, okay, by the way, we're laying you all off and we're going to start our remodeling plan. Well, because they didn't make clear that that needed to be the buyer's responsibility before the closing, and they made that announcement post-closing, that's going to be all on the seller. So it's very important to get that right in your sale documents. All right, so who do you have to give notice to? You have to give it, first of all, 60 days prior to the first covered employment loss. So even if you're doing it in a couple different waves, you need to give that notice 60 days before the first wave starts. You have to give it, if there's a union, you have to give it to the rep of the collective bargaining agent, okay, the union rep. If there's not a union, then you give it, or in all cases, you give it to the state representative. There's actually an agency within state government. There's a special office that's designated to receive these notices. And then the chief elected official of local government, usually the city or the county that you live in, or where the business is located, and each affected employee, okay? And there's rules for which affected employees are entitled to notice and which are not, and you'll have to work through those with your employment lawyer. Okay, who gets it? Each employee who's reasonably expected to experience an employment loss. Here you include the part-time employees, even though we weren't counting them for coverage as an employer. even though we weren't counting them for coverage of an employment loss, to test whether it was a plant closing or a mass layoff, they still get notice. I told you, it's weird. And you do not give it to the temporary employees. You don't give it to your partners, your consultants, or your contract employees. So that's who gets notice. Now, you don't have any obligation to keep employees performing their functions. So if you absolutely have to shut down and you don't want customers in your building anymore, you can shut down, and then you can pay your employees for 60 days of pay in lieu of notice and just tell them to stay home. And that will satisfy your WARN obligations because they remained on your payroll for the equivalent of 60 days. They got their 60 days of notice. Now, what happens if you mess it up? Any individual that was entitled to notice may sue if you don't give it. The limitations period is going to be governed by state law, and it's probably not going to be a jury trial according to the Sixth Circuit, but that has sort of bounced back and forth, and several courts have reached different conclusions on that. They can recover their attorney's fees by statute, so it's like all employment laws. If you lose, you might be paying their attorney for the privilege of getting sued. There's no right to injunctive relief to halt the plant closing. So if you give notice and somebody thinks it wasn't enough notice, or you have to close it without notice due to unforeseeable business circumstances, they can't come in and ask the court to force you to stay open. They're just going to have to live with damages as their remedy. And what you owe is you owe back pay for each day of the violation. And back pay is governed typically by the working day approach as to how many working days there were. So not necessarily calendar days, but in the case of a restaurant, it might be pretty close to that when you talk about working days. We're going to look at what days you're open and what days would normally be working days for you. Now here's some quirks. Like we talked about, you could be a covered employer like Fanny's Falafel was because they have 100 or more employees, yet not have any possibility of experiencing a plant closing or a mass layoff because all of your employees are dispersed at these small sites and you're never going to reach the 50 employee threshold. Remember, like we said, you might end up counting employees for some purposes, but not others. Those temporary employees might or might not count for coverage purposes, depending on which method we're using at step 1. They do count for employment loss purposes at step 2, but they're not entitled to notice. What about the part-time employees? Again, they might or might not count for coverage purposes on step 1. They do count for purposes of employment loss. I'm sorry, they don't count for employment loss purposes, but they are entitled to notice. Like I said, this is weird. This is why you call your employment lawyer. And in terms of layoffs, to know whether a layoff counts as an employment loss, you need to know whether it's going to extend beyond 6 months. You might not know that in advance. Maybe you're shutting down and you're anticipating your construction department has told you this site will be refreshed and reopened and all the construction will be done in 4 months. So we're just going to lay them off for 4 months. I might not know that there's going to be delays. It's really going to take 8 months because I have a bunch of dumb contractors, okay? Or we can't get the materials or the zoning department's not cooperating. As soon as it becomes apparent to me that that layoff is going to extend beyond 6 months, now I have to give WARN notice, okay? Once it becomes clear that that's going to go beyond 6 months. And I have to give 60 days notice before the earliest termination or layoff if we're talking about a phased RIF, okay? If I'm doing this in chunks, I might not know whether I'm going to have to do those additional rounds of layoffs in the next 90 days to push me over the threshold. So if I'm laying off 30 today, and then a couple weeks later, I anticipate I might need to lay off another 10, okay, that pushes me to 40. I might not know whether I have to do that next 10 or 20 that pushes me past 50. Again, it depends on what the employer could reasonably foresee. And there's a case out here that we look at to see what the definition of reasonable foreseeability is. Okay, so here's one, and when you get into bankruptcy, this can be really, really challenging because you might have people in bankruptcy that are claiming that they should have gotten WARN notice, even though you're bankrupt and you're out of business. Okay, well, the court in bankruptcy might argue that you're right in line with everybody else okay? And you are not a secured creditor, so you're just going to have to, go to the back of the line and wait it out. So you have to know your bankruptcy law also. Okay, it's been really complicated, so if you want to discuss it further, feel free to call me or send me an email. And with that, I think we're going to stop sharing the screen and go back to just a regular webinar. So did I do that right, Ashley?
You did. Thank you, Kevin. That was really great information. I don't see any questions that have been entered during this webinar, but please feel free to reach out to either Kevin or myself after the webinar if you do have questions, and we'll be sharing the video.
All right. Thanks, everyone. I appreciate the opportunity, and thanks for hanging in there.
Good afternoon.